morning and welcome to PV Legal's daily newsletter. Today's judgment comes from the Bombay High Court, and it is a decisive one for every GST-registered taxpayer caught in the inverted duty structure trap. The case is CHECTPL Line 4 Joint Venture versus Union of India, decided on the 23rd of April 2026 by a division bench of Justices G.S. Kulkarni and R.T. Sathe. Here is the background. The petitioner, a joint venture between China Harbour Engineering Company and Tata Projects Limited, was constructing metro rail infrastructure for MMRDA in Mumbai. It paid GST at 12% on its outward supplies, but procured inputs and services at 18 and 28%. Classic inverted duty structure, classic ITC accumulation, and a legitimate refund entitlement under Section 54 subsection 3 clause 2 of the CGST Act. The petitioner filed 7 refund claims totaling over 12 crore rupees. Both the original authority and the appellate authority rejected them. The core reason? That the corrected refund formula, introduced by Notification Number 14 of 2022 dated the 5th of July 2022, applied only prospectively, meaning only to refund applications filed after that date. Now here is where it gets interesting and infuriating. The corrected formula in Rule 89 Sub-Rule 5 was not some policy largesse gifted by the government. It was the direct result of the Supreme Court telling the GST Council, in plain terms, that the old formula was skewed in favor of revenue, created inequities, and needed to be fixed. The Council fixed it, and then the CBIC issued a circular declaring that the fix would not help anyone who had already applied for a refund. You could not make this up. The Bombay High Court has now put that circular exactly where it belongs. Following the Gujarat High Court's landmark ruling in Ascent Meditech Limited versus Union of India, which had already been affirmed by the Supreme Court after the government's special leave petition. And even the review petition were both dismissed. The Bombay High Court held that Notification Number 14 of 2022 is curative and clarificatory in nature. It therefore applies retrospectively to all refund applications filed within the 2-year window prescribed under Section 54 subsection 1 of the CGST Act. The court relied on the Supreme Court's rulings in Allied Motors Private Limited versus Commissioner of Income Tax and Collector of Central Excise, Shillong versus Woodcraft Products Limited, which firmly established that curative amendments operate retrospectively. The orders in original and the appellate order were both quashed. The petitioner's entitlement to refund under the corrected formula was unambiguously affirmed. The message for taxpayers is clear. If you filed your inverted duty refund claim within 2 years, and it was rejected on the ground that Notification 14 of 2022 does not apply to you, that rejection is wrong in law, and this judgment is your weapon. This is your host, signing off for PV Legal's daily newsletter. Stay informed, stay vigilant. Good day.